John McKee, Interim Associate Vice President for Philanthropy and Planned Giving for the University of Maryland, Baltimore. It's my pleasure to introduce our third speaker. Christopher B. Walter is an attorney with Davis, Agnor, Rapaport, and Skalny, and leads the firm's estate planning practice group. His practice focuses on estate planning to help his clients prepare for the unexpected and estate administration to help make sure a loved one's wishes are carried out. Chris realizes that estate planning is the easiest thing in the world to put off, and that's why he's committed to making the process comfortable, easy, and accessible. Whether it's making sure the right people are in charge of caring for your children, drafting trusts for special needs beneficiaries, engaging in complex estate tax planning, or crafting documents to account for any number of unique circumstances, Chris has worked with thousands of Maryland individuals and families to put together the right plan for them. Chris earned his BA from the University of Maryland College Park and his JD from the University of Maryland Francis King Carey School of Law. He has been admitted to the bar in the state of Maryland and is active with the Maryland State Bar Association, Howard County Estate Planning Council, and the Baltimore County Estate Planning Council. A longtime resident of Howard County, Chris is proud to give back to his community, serving on the Community Foundation of Howard County Board of Trustees and the fundraising committee of the Ohana Howard County. Chris will be presenting on the subject, what is an estate plan and why you need one. As with prior sessions, please type your questions into the chat and I'll present them to Chris to answer at the end of his presentation. Chris, the floor is yours.
What John didn't mention in there is he and I are former colleagues as well. I worked previously in a past life in the gift planning office at the University of Maryland College Park with John McKee and Patty Wang back when John was there. And then I moved up to the University of Maryland, Baltimore, and did some fundraising for the law school. So it's nice to be working with old colleagues again. So my presentation today is about planning for your future. What is an estate plan and why you need one? And we are going to be covering really three major things here. First, what is estate planning? What are we trying to accomplish in that process? There's also, how do I make an estate plan? And just generally the estate planning process from beginning to end if you are working with an attorney. So what is an estate plan? It's really two basic things. We're either planning for what happens if I'm alive but disabled, and then planning for what happens after I pass, how to make sure my assets get where I want them to go, and making sure I've got the right people in charge. Normally, we do this with a series of documents. For planning for disability, it's typically powers of attorney, medical directives. And if you don't have those, or sometimes even if you do, there's the guardianship process. And then with planning for death, the core document is the will. Sometimes there are also revocable trusts and beneficiary designations and proper titling of your other assets is really important. You can have the best will or best trust in the world, but if you don't have all of your beneficiary designations lining up with the rest of your plan, some unintended consequences could certainly arise. I'm going to start with talking about planning for disability. And the first question is, who is legally authorized to make decisions for me if I cannot make them for myself? Well, there's a guardian of the person or guardian of the property. There's an agent under an advanced medical directive or an attorney in fact under a power of attorney. And that's it. That's the only group of people who are automatically authorized, not a spouse, not an adult child. So having these core set of documents are really important to make sure that somebody can step in. So some of our objectives for planning for disability are making sure you've got the people you want, not sort of the defaults the court decides if you go through guardianship, making decisions for you. Guardianship's also expensive and time consuming, and it avoids that cost, and it reduces uncertainty and family stress. I want to talk for a moment about the guardianship process. This is really not planning. This is what happens when you don't plan. It can only happen after a person becomes disabled. It it's very intrusive. You need attorneys often. There are court filings, hearings. You need to keep accountings of everything in the guardianship estate. Um, and it can be properly avoided with an advanced medical directive and a power of attorney. I'm going to start with the advanced medical directive. Uh, this, as the name suggests, is designating somebody to make medical decisions on your behalf. Uh, so that's the declarant, or the person who is making the directive is the declarant. You are expressing your wishes regarding end of life care. It can also authorize somebody to make funeral arrangements on your behalf and can give instructions to them in that document. The medical directive has three core parts. Part A is where you're naming your agent and you're giving them their authorities. So that's where you say, my spouse or my sister or my adult son can step into my shoes and hire and fire doctors. They can manage my care. They can make certain end of life decisions. They can ride with me in the ambulance. They can fill out a do not resuscitate form on my behalf. Part B is where you give your directions to the physicians in one of three circumstances: a terminal condition, an end stage condition, or persistent vegetative state, and there's no reasonable hope for recovery. It's essentially if you're at a point where the only thing keeping you alive is life support, or you'll have just an unacceptable quality of life. And it allows the doctors to remove that life support, but to make you comfortable, if that's your wish. It can also say, keep me alive for as long as you can. So it's where you're giving your instructions. And then part C is about funeral arrangements, cremation, burial, organ donation. You can put instructions in there. Or if you don't have specific instructions, or you've written them separately, you can authorize that person you've named in part A, your agent, to make those decisions on your behalf and to carry out your wishes instead of just leaving it to the scrum and everybody's trying to figure out who's in charge, who's doing what. I want to take a quick second to talk about the MOLST form. If I didn't turn off my audio there accidentally, I was messing with my headphones. Somebody will pop in if I did. The MOLST form is medical orders for life-sustaining treatment. It's what you might have heard commonly referred to as a DNR. This is a physician-prepared document, and often it's the one that physicians are going to want to look at, but it really should be in sync with your medical directive. It's the one giving the nitty-gritty decisions. If I'm in cardiac arrest, do I get CPR? So it's an important document, one that isn't part of the process you do with a lawyer, but is still very important when you're considering all of these decisions. So that's the medical directive. The power of attorney is similar. It's, again, planning for disability, but instead of being for medical decisions, this is for legal and financial decisions. Who can pay my bills, who can file my taxes, who can sue people on my behalf, who can make certain estate planning decisions. So very powerful document. It authorizes a trusted individual to make decisions on behalf of the principal. That's the name of the person making the document. You might hear them referred to as an attorney in fact or an agent. And like the medical directive avoids guardianship of the person, the power of attorney can help avoid guardianship of the property. So this is just a quick breakdown of who does what. The agent under the medical directive, or the attorney, in fact, under the power of attorney. So just a helpful grid on what their authorities are, and where they can be used. And I'm not sure if it was mentioned, but I'm happy to circulate the slides afterwards for anybody who wants to look through and use this as a reference. So those were the very basics of planning for disability. The next portion is planning for death. And these are some of the objectives that we have when we're talking with clients about making these preparations. The first is providing for spouse, family, loved ones, the University of Maryland College Park Foundation, whatever charities you want to support. It directs that your property goes to who you want, and not what the defaults are under the law in absence of a will. You can benefit your loved ones in trust, which can help provide some extra protections for them. And we'll go into that a little bit later. There's some tax optimization and just minimizing expenses and headaches. So before going into the nitty-gritty of what's a will, what goes in there, I want to take a step back and talk about the different ways property passes at death. There's really four ways. There's, and I'm going to start with this non-probate side, which covers three of those buckets. Bucket number one is if you own something jointly. So my wife and I, we own our house together. If I die, it's hers. She owns it just by operation of law. Same is true with our joint bank account. Contract property, death benefits, those are like beneficiary designated property, most often life insurance and retirement accounts. Also, if you're in a continuing care retirement community, it can be the refund of a deposit from that. Bucket number three is property owned in a trust. So if property's in a trust, when somebody passes, then the trust can say, on my passing, it goes to X, Y, or Z, and sort of act as a will substitute. And then bucket number four is everything else. It's everything you own in your sole name at the time of your death, with no beneficiary form associated with it. That's what, if you have a will, that's what goes through your will and what goes through the probate process. So what is a will and why do you need one? The components of a will, you've got some tax and administrative provisions. Some of those can be very helpful in making sure you don't face unnecessary expenses, or you don't need to ask the court before making certain expenditures. There's a limit that you can spend on a funeral without specific authorization in a will. Otherwise, you need to ask the court for permission. Of course, it directs what happens to your probate assets at your death. It can establish trusts for beneficiaries. Sometimes they're special needs trusts, trusts for spouses. And it names your fiduciaries, which are the decision makers under your document. So the three most common types of fiduciaries are personal representatives. That's what Maryland calls the executor role. There's guardians for minor children. And then if you establish trusts, there are trustees. Special considerations for your will. This was covered some in the prior sections, but it's worth sort of noting again what you need to be thinking about when you're going through this process and crafting a will. These are some of the highlights. That is there somebody who has special needs and is going to get a means tested government benefit like Medicaid or SSI? Is there somebody who's too young or too immature to handle getting inheritance from you? Or are you comfortable with everybody receiving it outright? Do you have specific things that you want to go to specific individuals? I want my engagement ring to go to my oldest granddaughter, things of that nature. Do you want to put in extra safeguards about your beneficiaries, creditors, or your in-laws ever being able to benefit from what your children inherit? Do you have a blended family, and do you need to make some special considerations for the assets of the two different partners? Well, all of these questions need to be addressed in a will or a revocable trust. Let's talk about what happens in the absence of a will. So, kind of like in the absence of the power of attorney and medical directive, you have the state stepping in with the guardianship regime. If you don't have a will, the state of Maryland has been kind enough to write one for you. Got some defaults in it, and most of them make sense. It will go to spouse or children or your other close relatives if you don't have one. But you're losing control of who it goes to. You're losing control of how it passes to them, and it can lead to some pretty significant unintended consequences. Um, Also, some of those administrative provisions, well, none of those are in a will if you don't have one. So it can lead to time, cost, and expense. So that's the intestacy uh, laws of the state of Maryland. So with either a will or intestacy, that's what passes through the probate process. Probate has this big scary rap. You hear the word, and a lot of people feel like they need to contort themselves to avoid probate. In some cases, that's true, but in a lot of cases, probate isn't adding that much undue delay or time or expense. It's a process. And it's the legal process supervised by the court or the register of wills, where they determine a will is valid, they name the personal representative, and the personal representative is charged with following the instructions in that document, and the court supervises it. In the Maryland courts, unless there's some controversy, typically have a hands-off approach to intervening in probate. Still, sometimes it makes sense to avoid probate. And there are a couple tools we use. If we go back to thinking of those four different buckets, the ways which property passes at death, you had the joint titling, the beneficiary designated, revocable trusts are the one that this focuses on. Revocable trusts are really just will substitutes. They're an entity that you create during your lifetime to own property. So if I had a revocable trust and Chris dies, Chris doesn't own his house, Chris's trust does, meaning it doesn't go through probate, it goes under the terms of his trust. So it can be useful in a couple of different scenarios. The first is privacy. Not that your will is, published on the internet or anything like that, but it is a public document in the public records that any Tom, Dick, or Harry can go down to the courthouse and request a copy of it and see not only the will, but also a list of all the assets that went through probate. It can also be useful if disability is imminent. Trusts have a trustee who manages them. Normally, if I'm making my own trust, I'm my own trustee. But if I'm ever disabled or after I pass, my successor steps in and can manage the trust-owned assets fairly seamlessly. Real estate in multiple jurisdictions. So that probate process happens in two places. It happens wherever you are domiciled and wherever you own real property. So if I've got the beach house in Florida and I'm still a Maryland resident, if I die, I've got Maryland probate from where I live, and then I've got Florida probate from where I have that beach house. But if they're both in the trust, I've avoided probate in two places. And not every state has as seamless a probate process as Maryland. Also, closely held business interests. Oftentimes, you just don't want that as part of the public record. If you own your own business, there's going to be a value attached to that at your death that you may not want to report as part of the public record. And probate fees. Probate fees used to be pretty flat. There's a new law passed a couple years back now that made them more progressive, meaning the larger your estate that goes through probate, the higher the fees you're going to have to pay, and it can get up to $10,000 plus for big estates. So for large estates, it just makes sense to avoid that cost and put everything in your trust. So that's avoiding probate. With revocable trust. You set it up kind of like a will. You're making all the same decisions. Again, it really is just that will substitute. But at the end of the day, you have this entity, and it's going to hold title to your assets. Also, other ways to avoid probate are through joint titling and beneficiary designations. These can be useful tools, and we use them often. It's just something you need to pay extra care to. Now, for joint titling with spouses, especially with spouses in a first marriage, it's very common to own everything jointly. But I hear all the time, Mom added my sister to this account so she can help manage it. Well, if Mom and sister are joint on the account, when Mom dies, that's sister's account. Maybe she, you know, spreads it out among the other siblings, but she's under no legal obligation to, typically. Also, now that account is subject to creditors of sister. If sister gets sued, well, now that's part of her assets, and there can be a claim against what really is. So, joint titling, useful to do in some cases, but something that should be done with some care and thought. Beneficiary designations need to happen on a lot of assets. Retirement accounts and life insurance typically have beneficiary designations, but it needs to be done consistently with a will or a trust. Let's say I have a will and I've got young children, and they are, they're good kids, but they couldn't handle the proceeds of my life insurance policy if it went into their hands. So my wife and I, we did wills that said everything goes to my kids in equal shares, and we've got all these fancy trusts set up in there. My brother's going to manage it, and they're taken care of. Well, they get whatever goes through probate through my will in those trusts, but they might have this life insurance policy or these retirement accounts outside of probate, and that kind of undermines the purpose of the trust and creates a whole other mess. So it's important to do in conjunction with your attorney, and something we always counsel our clients on. So those are the very basics about what is a will, what is estate planning. I want to focus now on how do I actually make an estate plan? How do I put one together? And start with the legal requirements for those documents that we just talked about. This is all that's legally required for a will. For most wills, there's an exception for holographic wills, which are battlefield wills in your own handwriting with no witnesses. But for any other regular will, you need to be 18 years or old. You need to be 18 years or older. You need to be legally competent. And it needs to be in writing, signed by the testator, the person making the will, in the presence of the witnesses and two witnesses. And that's it. Doesn't need to be notarized, doesn't need to be on any fancy it doesn't need to have all those trappings. So pretty basic to put one together. Similarly, for the power of attorney and medical directive, the state of Maryland gives you the forms. The power of attorney form is in the Maryland Code. The Attorney General publishes a sample medical directive, and these are what we base our documents off of. We feel like we add some really important provisions to them, but this is where the core of all those documents comes from. different ways to make an estate plan: DIY, online forms, or with an estate planning attorney. I'm going to start with DIY and online forms. This is a sort of funny poem that I've run into and referenced from time to time about the testator who makes his own will. So feel free to read that if the slides are circulated. Um, it's an option. They can have unintended consequences. Sometimes they are worse than nothing. So I'll give you some examples. Um, I had a client that uh, had a will, and the will said, I give I give these assets to my wife, but I give this life insurance policy to my daughters. It was a second marriage. Um, he died. His ex-wife, just by operation of law, was out of the will. Um, and he had that life insurance policy that he thought was covered because it said in the will it goes to my daughters. Well, guess what? It was beneficiary designated to his ex-wife. He ended up with $1.5 million of non-probate property that he thought was covered in his will. Um, Things like administrative provisions. Got another example now where there's this client with an online account, and the bank is being a real pain. And they're saying we can't transfer it over and give online access to the account to the personal representative of the estate, which, BS, but it's what they're saying. Well, there's this thing called the Fiduciary Access to Digital Assets Act that Maryland passed that said that your fiduciary can get access to your online accounts. There are two ways to do that. Either you put in your will, hey, my executor, my personal representative can access my accounts under this act, or you petition a court. He used an online form, and if the personal representative wants to get to that account, he needs to get permission from the court, needs to get a court order, and that's a pretty significant expense. We're weighing the pros and cons. Then there can be confusing or contradictory language. This is one that we run into all the time, where it's one of those you don't know what you don't know situations, and what you are writing down might seem perfectly logical in the moment, but you're ending up contradicting another provision of the document. And that can lead to litigation. That can lead to your beneficiaries fighting or just uncertainty. So it can be avoided by going to an estate planning attorney. And I know this is, you ask the surgeon if it's a good idea to operate, they're going to be biased to say yes. But the benefits of going to an estate planning attorney are they're up to date on the changes in the law. They are able to understand what's in the document and customize the documents to your specific situation. And they carry malpractice insurance. If I screw up, that's something between me and my clients, and they can go after my insurance or my license. So I've got a responsibility to act in their best interest, and there's real consequences if I get it wrong. But with that, if you end up going to an estate planning attorney, what can you expect? What is that estate planning process? I'm just speaking from my personal experiences. I've worked at two different firms now, and from my experiences talking with my colleagues through the Bar Association and other estate planning groups. The process. So first you start with an initial meeting. Some attorneys do free consults. Most attorneys are going to charge for an actual consultation where you're sitting down and they're giving you legal advice. And they should be upfront with, hey, if you come in to meet with us, there's a consult fee, and here's what it is. If it's you want to give us a call and take 15 minutes of my time to see if you're comfortable proceeding, or just to learn a little bit about, kind of have this conversation, that's totally fine and not something that most attorneys typically charge for. But you probably should expect to have some sort of consultation fee if you're engaging the attorney to do an estate plan. Attorneys will often request information prior to that first meeting. Um, we have an intake form. You know, it can be lengthy and intimidating to look at because we're trying to get the information we need to have a productive first conversation, and to really make sure we're spending our time wisely and efficiently. Um, that'll ask for things like what are the names and contact information for the people you're going to name in your documents potentially. It's going to try and spot some issues that'll send off some warning flags to us that, hey, this is something we need to spend some time and attention on in our meeting. It's going to ask for an outline of your assets, and who owns what and what the magnitude is. So we know, hey, do we need to start talking about estate tax planning? Do we consider Medicaid planning, etc.? So don't let that form be the thing that stops you from coming into the office and having that consult. There are a lot of places where it's easy to kick the can down the road with estate planning. I tell clients, just do the best you can, put as much information as you can down. Cost. How do attorneys bill and what can you expect? Well, there's two basic types of billing. There's flat fee and there's hourly. Um, Flat fee is after we've sussed out the documents, we are going to give you a fee quote for what it's going to take to do the documents as we've outlined together. Hourly is we're going to track our time and just bill you for however much time it took us to complete your estate planning documents. Most estate planning engagements are flat fee. It can be hourly when it makes sense. If it's open-ended or if there's a novel issue and we just don't know how much time it's going to take, because the flat fee is normally based on our estimation, how long and how much time it takes. We're hourly billing. If the attorney's doing that, there's typically a reason. Sometimes we also do billing or hourly billing for small changes to the documents. If we're just updating, some names, you've come back to do some quick updates to the documents. That's not really read off a fee schedule, at least at our firm. But like I said, needs to be open and transparent. A lot of firms will do an engagement letter where they outline, hey, here's the work, here's how we're billing, here's how we expect to be paid. So don't be surprised if you get that. And the fee is going to vary based on the experience of the attorney and based on the law firm you go to. To give you a very general sense, there are attorneys out there that do these estate plans for $500, for $1,000, for $1,500. Our firm, our typical range is between 2,000 and it probably 4 to 5,000 is the normal range for most of our estate plans. But it really can vary. We do share our fee schedule with clients in advance of them ever walking in the door, so they're not surprised when we're sitting down at that consult meeting on what they can expect to hear as a fee quote. I will say that oftentimes this is you get what you pay for type of business, and that you will expect a different level of comprehensiveness and service, depending on the fees that you're paying. So, had the initial meeting. You've talked about costs. You have a fee quote, and you understand what it's going to cost. Next step is the attorney is going to prepare documents that you've agreed on, and will review them with you. Sometimes those documents are sent out in advance. Sometimes they'll just meet with you to review in the office. No matter what, you should always have the chance to review with your attorney, ask questions, make changes, and be comfortable with the documents. Most of the time with our processes, we'll send out the drafts. We'll have some explanatory language that's not part of the wills themselves throughout in these gray boxes that give plain English synopses of the different important provisions. And then we'll say, take a look at it, but let's come in and meet and walk through it together to make sure you're comfortable. Sometimes we'll have some back and forth about appropriate changes to the documents, and then we finalize them, and we're at the easy part, which is getting together to review and sign. That's just putting pen to paper at the end of the day. So after the documents are signed, there's an important question about where should these be stored? What happens to the documents? And there's really three locations, potential locations. First, you can take them yourself, and then you can put them in a safe deposit box or a safe. Um, and that can be fine. That's common with solo attorneys that they'll say, hey, just keep your will yourself because they don't really have the infrastructure to hold on to it. The one issue with that is if you are holding on to your will and it gets lost or it gets destroyed, it's presumed to have been revoked. Whereas if it's in the hands of some third party, there's kind of a chain of custody, and you can say, yep, that's my will, and you can admit a copy of the will to probate in that case. Second is with the Register of Wills in your county. The register will hold a will on deposit there, costs $5 to hold a will, and they'll need the last four of your social. And then it's there with the register until you take it out or until you pass away. Third is in the hand of some third party, and most often that's the lawyer that drafted it. It's common for us to hold on to our clients' executed estate planning documents. So if they need to make updates, we're not going back and forth with the register. And after they pass, their beneficiaries have the ability to sit down with us and the people that help craft their plan and work with them on how to get everything from point A to point B. And then there's the follow-up. So this, like I was mentioning earlier, is just as important as the documents themselves, making sure that beneficiary designations and the titling of your assets are up to date. Let's say you have that revocable trust. Well, if you have a revocable trust, but you never move the assets into it, you're still going through probate. You're just going through probate to get to the trust. If you have, like I was mentioning earlier, trusts under your documents, you say, establish that trust for my kids, and your beneficiary designations don't point to the right place, again, that can have those unintended consequences. So if you're talking with an estate planning attorney and getting an estate plan, they should be giving you specific advice on these beneficiary designations. Oftentimes, it's going to be one of those things where you're going to have to do some of the legwork yourself. You're going to have to request the update form, but it should be spelled out pretty clearly on what you need to do. And then future follow-up, how often should you look at these documents? We encourage our clients to take them down off the shelf and review them every year or so. And we send a letter to our clients every 3 years, not to say, hey, you need to make changes, but just again, reminding them to review the documents to see if there's anything in their lives that have changed and alert them to any big changes in the law since they were last in. So how long should this process take from beginning to end? Well, lawyer answer, it depends. It depends on your specific situation, your ability to make decisions, and your attorney. So oftentimes attorneys can work on an accelerated timeline in an emergency. I've done, unfortunately, a number of deathbed wills where I'm at the hospital, or I'm at the bedside at the home getting something signed. But that can lead to increased costs. If we're in those situations, sometimes we're able to accommodate it without the increased cost, but again, it's going to depend. The typical turnaround is a month or two. It's not uncommon for, in some practices, to take more. Normally from that first meeting to me getting drafts out to a client, it's 2 to 3 weeks if we're especially busy. Sometimes it can be a little bit longer. If they say, hey, I've got vacation coming up in 3 weeks, then we'll know, bump it to the beginning of the list. But again, that should be part of the communication process between you and your attorney when you're getting engaged with them. So how the heck do I find an estate planning attorney to do all this? Well, first, you can email me. I'm always happy to help. But second, go referrals from trusted friends, family, and advisors. We end up getting a lot of referrals from people who have used our services in the past, or professional advisors that we work with who have trust and confidence in us that we're going to do a good job for their clients. They've seen our work product and they're comfortable with it, and they know we're going to follow up and follow through. If you don't have anybody in your network that you feel like you can get that advice from, online reviews from trusted sources. But when you're look for experience of the attorney, and look and see if they specialize in that type of work. Speaking of some red flags, some things to consider, just because there's a little alarm bell doesn't mean this is a bad attorney or you're going to get bad work product, but just some things we've seen in our experience to look out for. One size fits all. A will mill, a trust mill, are sort of the names we've had in our practice about people who just get them in, get them out, and aren't really taking the time to personalize the experience. They're not transparent on price. Of course, they'll need to know your situation before you actually get a comment on how much it's going to cost you. But that needs to be something that's open and transparent through the process. They're not answering your questions. If you don't feel like you can have that dialogue with your attorney to get to the documents you want, they don't take the time to explain to, if they just rush you through and say, no, this is what you need to do. If they don't specialize, with the caveat that, not everybody who does a couple things does any of them poorly, but this is a complex area of law. I'm learning new things every day. My colleagues who have been doing this for 30, 40 years are learning new things every day. The law changes quite often. And it's something that you really do want to see somebody who specializes if they're doing these important documents for you. They won't do the follow-up, if they won't give you that advice on beneficiary designations and asset titling. And then finally, the most important thing is trust your gut. You should be interfacing with somebody that you are comfortable with. So no matter what, that's a really important component. Make sure that this is somebody that you feel comfortable when you're going to feel like that you've got trust and confidence that they can guide you through the process and explain things and make you comfortable and get you together with a good set of documents. That is the sort of scripted part of my presentation. Thank you all for joining. I've seen some questions in the chat, and I think John was going to step on and throw some of them at me.
What is a trust?
Sure, that's a great question. A trust is back up. So if I have a bank account I'm the person who started the bank account. I'm the person that can go in and take money from the bank account and use it for my own enjoyment. And I'm also the person that can manage the bank account. So I'm wearing really three different hats. What a trust is it's breaking up those different hats into different jobs. It's an arrangement where you have, sometimes it's called the grantor or the trustor or the settlor, but that's the person who sets up the bank account, sets up the trust. You have the person who has the legal responsibility for managing the trust, that's the trustee. And then you have the person that can benefit from what's in the trust, and that's the beneficiary. So it's breaking that ownership up into three different components, and you can have trust for all different types of reasons. So, for example, the revocable trust for probate avoidance, well, you're typically wearing all three hats. You are the settlor, you're the person who started it, you're the trustee, the person managing it, and you're the beneficiary during your lifetime, the person who can take money out. You have trusts that are set up in a will or a revocable trust at your death for the benefits of your kids, a spouse, a special needs beneficiary. There, you might name a sibling or a trust company as the trustee. Uh, then it's for the benefit of a child, and you are still the settlor or the grantor. Or this is a little more niche. There are irrevocable trusts that you can set up during your lifetime. That's often for estate tax or Medicaid planning purposes. Those don't come up quite as often, although we still handle a good bit of them.
So basically, it's a standalone legal entity with a special purpose, with a
That's
specific
exactly
purpose.
that's exactly right, Jim.
Okay, good. Um, next question. What if your stepson lives in Germany and has no social security number in the US? Can he inherit financially or property?
Absolutely. So now getting the assets from point A to point B can, you know, be a little bit, there might be a little bit of work in the administration, but you can name foreign people under your documents, under your will, under your revocable trust, or under beneficiary designation forms to inherit. That comes up quite often.
Okay, great. Um, as active duty military family, if the military member or spouse passes, will probate occur in both the state where you are currently stationed as well as where you hold property and or your home of record?
Yep. So your domicile is, so it certainly happens wherever you own real property, and then it happens wherever you are domiciled. Domicile is considered where you live without intention to return anywhere else. So domicile with the military can be tricky. Oftentimes, if you're stationed in a U.S. state for a period of time, that 3-year rotation, that's going to be considered your domicile, and you'll have, if you're stationed in Maryland, you'll have Maryland probate, and you'll have the ancillary probate wherever your property is. For foreign deployments, oftentimes your domicile is still considered what your domicile was before you were deployed. So again, the lawyer answer, it depends.
Okay. What can we expect to pay a state lawyer for relatively simple estates?
Again, that's going to depend on the lawyer that you end up going to, their experience, what they consider as part of the process. There are some law firms where it's, you pretty much fill out an intake form and they generate a will and they send it off to you to sign, and you're not really getting that interaction. That can be a couple $100. If this is a attorney that you are sitting down with and really getting into the details of your situation, even simple plans, I sort of gave the example of our ranges. $2,000 is sort of I wouldn't say the minimum, but that's about the lowest amount we typically charge for new documents for new clients. So again, it is going to depend. Also, I will say that even if you believe your situation to be simple. Oftentimes, your objectives can be simple, but the situations are sometimes more complex than they appear. I'll give an example of my mom. It's me and my two siblings, and we get along great, and there's no discord. She's married; it's a second marriage, and he's got children of his own, and everybody agrees on the plan. But their house is titled jointly, even though it's the house that she purchased with her money. Um, she wants that to go to us, but that's not how it would go under how it's currently set up.
Mhm.
Um, he owns foreign property in Canada, and there are all these things where the objectives are simple, but the situation might have more than it appears, and warrants further conversation.
Okay, great. What happens to the information you have provided to an attorney if you decide to not go with that particular attorney?
So, like the intake information and all of that. So they will sometimes just keep it in if you send the information off to them and you don't engage with them, uh, that's still going to be privileged. They can't go share that with anybody else. I've got clients all the time, or prospective clients, I should say, that inquire and maybe get a few steps in the process and then decide that either they're not ready or they need to put it on pause. And we just hold on to that in a sort of prospective client file. And if you ever re-engage, we have it for our records.
Okay. Uh, Next question. There are lots of different types of lawyers. Who do we go to for what? For example, tax considerations, will, power of attorney, trust, medical considerations. Is it an estate planning attorney, an elder care attorney, financial planning? Go to the same person or different person?
Got it. So there are some jobs that are right for an attorney to handle, and there are some jobs that we leave it to other professionals. And like you mentioned, there are a lot of different types of attorneys. Um, we consider our practice here estate planning and elder law, meaning that we are covering all the things that we talked about in our conversation, plus tax law. That's a big part of it, especially as it relates to estate planning. Um, for financial advice, oftentimes you'll go to a financial advisor. For specific income tax advice, you normally have your CPA or accountant, and we work together as a team to come up with the plan that's right for you. Um, there are some things that a lot of estate planning attorneys, myself included, don't do. For example, Medicaid qualification. We can give you some Medicaid planning advice, but if it's actually trying to qualify for those certain special needs benefits, there are attorneys who specialize in doing that. But when it comes to getting those core estate planning documents together, making sure that we're taking a whole picture of what your assets are, what the tax implications are, what the blended family situation is. That's something that an estate planning attorney should be equipped to do.
Okay. What about the online trusts? I'm thinking of one that we see on MPT or WETA. It indicates that they meet each state's laws. It can also be updated much easier.
Um, Again, this is one of those things that it's so we have an estate litigation department here at our firm, and our estate litigator Angela is fantastic, and she makes most of her money off of these types of online DIY forms that go awry. Trusts are complicated. It's not a simple thing to put together. Um, Trust, yes, it's going to say they look at the laws of each state. How often do they update it? Are they taking into account your specific situation? It's all those things that where you don't know what you don't know. You're not able to assess the quality of these documents. And by the way, it's not targeted at any one person. That there are a lot of brilliant people that I interact with every day. They just don't know this area of the law. It's what I've immersed myself in. Um, So it's not a slight to say that you don't have an understanding. It's taken me and my colleagues a long time to get this level of understanding. And we see the bad cases all the time from these types of online forums. So I would caution you to stay away.
Good, thank you. If I want to set up an attorney to be executor of my estate or to be accessible to a family member, how would I identify someone to serve in that role?
Sure. So estate planning attorneys often do serve in that role if it's the right fit. I should put as a red flag an estate attorney who's going to automatically put themselves in that role. But if you've met with an attorney to help you prepare the documents, that's a question you were going to want to ask them about. Are you the appropriate person, or could you be the appropriate person to serve in that role? Now, that said, if you get it set up, the other thing you need to do is make sure that the beneficiaries, your loved ones, uh, they know who the attorney is and how to get in contact with them when you pass away, so the ball can get rolling and the instructions in your will can get carried out.
Okay. I think I can answer this for you. The question is, who holds your documents again for $5? And you said the Register of Wills, right?
The register of wills, yeah.
Register of Wills will hold your documents for $5. What about a copy of the trust, if I can't find the original?
So a copy of a trust, if you can't find the original, is typically going to be accepted. This is one of those case by case things, though.
Oh, I think the person's asking, where could they get a copy of a trust if they can't find the original?
Got it. So when we prepare documents, and hopefully this answers the question, you know, once a document's done, somebody is charged with holding on to that, whether it's you or whether it's your attorney. If the document gets lost, that can present a pretty big issue because there's no trust registry, there's no place to go. So oftentimes it makes sense to have an attorney or a third party hold on to that trust. The Register of Wills will not hold on to trusts. Also, in situations like these, we do make copies of the documents. Even though we'll hold the originals, you'll hold copies, you'll have electronic copies. And oftentimes electronic copies for trusts and for powers of attorney are treated as just as valid as an original document. The original will, though, there's something
Yeah,
specific about that.
He's clarifying. He means what you were talking about. I'm sorry. I didn't mean to interrupt the chain of thought. He means I only have a copy of the original.
Yep. So that oftentimes won't present a problem. I haven't really seen many institutions insist on the original, but it's good to know where the original is.
Okay.
Make sure you have backups of that copy.
Okay. Let's see. Okay. I'm not sure we'll get through all these, but let's see. Is there an easy way to find out if your will is with the Register of Wills? I had a will made up by a lawyer who's now retired, and I only have a copy, I think.
Yes, you can call any one of the registers. There's a database that they all have. So they'll know if it's filed in any county.
Okay. Why would it take more than 1 to 2 months in a non-emergency situation? And I'm guessing they're asking about, doing a will.
It can depend on how busy the attorney is. It can depend on how many decisions there are left to make. If there's a lot of back and forth between the attorney and the client, like I said, oftentimes we'll get initial drafts out within a couple of weeks, but then it's reviewing the drafts, making sure you're comfortable, making sure you understand, and that can take some time. Sometimes there's also, especially in trust situations, you're coordinating with third parties for beneficiary designations and things like that. And if it's on my schedule, it's just how busy I am dictates how quickly I can get through the work. If it's on other people's schedules, I lose control of that somewhat.
Okay. If a revocable trust is created, the trust then needs to file a yearly tax return?
That's an excellent question. And the answer is no. So the trust, a revocable trust, is kind of a disregarded entity for tax purposes. The IRS sees that if you're wearing all three of those hats, the settlor, the trustee, and the beneficiary, they're just going to treat that trust as you, and any income realized by that trust is going to be reportable to your social security number. Nothing else really changes except that the property is owned by you, comma, trustee, instead of you, comma, you.
So the trust typically does not owe taxes?
It's going to be a revocable trust is
Mhm.
tax neutral. An
Yeah.
irrevocable trust is going to have its own tax ID number, and that can depend.
Okay. What's the difference between Maryland, DC, and Virginia, in case I move?
So the basics are the same. They all have very similar laws that govern property and powers of attorney and healthcare directives. There's differences between the forms. There's some differences between the signing requirements in the different states, and there's differences in the probate process. For example, Virginia's probate process is not nearly as easy to navigate as Maryland's. So probate avoidance might become a bigger topic in Virginia than in Maryland.
Okay, we'll try to rip through these last couple ones.
Sure.
What benefits, if any, are there to choosing an attorney in your home county of residence?
Um, I wouldn't necessarily say your county is the most important thing. There is some
It's the
geographic
state.
convenience. It's the state.
Mhm.
They do probably have a better relationship with their county's register of wills for after you pass away. They might
Mhm.
know the people down there a little bit better, but it's really the state.
Okay. When is the good time to share your personal resources, bank account, username, password with your power of attorney? How much percentage of contribution should I pay for my power of attorney?
So couple questions in there. Sharing information, that's something where your attorney, in fact, should know how to get a hold of the information. Um, Sharing it and actually making it available, saying, here's all my bank account information, here are my passwords, that's going to be a comfort level. If you're 87 years old, your adult children are starting to manage things on your behalf, they're going to probably need to know everything. But if you're 45 and it's your brother, you may not want to give him your bank account password. In
Mhm.
terms of what they get paid, um, that's you know, oftentimes attorneys, in fact, under the power of attorney, can take compensation. That's normally defined as reasonable compensation. You can prohibit them from being compensated in your documents if you want, but it's going to depend on how much work they actually do when they are doing the work of managing your affairs.
Okay. I think that's all the time we have. We have 12 minutes until our next presentation. So Chris, I will get these unanswered questions emailed to you, and you can choose to respond directly to the people that post them if they're not anonymous and attached to a registration. So thank you very much, Chris, for sharing your expertise with us.